lot of people who commit crimes, but they have these dual diagnoses. They're substance abuse or a mental health issue. I say that just because I think the public, not you people, you look pretty invested in it, but the public thinks that it's all black and white and we're processing by numbers, and we're not. Everyone's an individual and everybody has rights, which I'm fully in favor of. But it is difficult. Sometimes they don't fit under a certain thing. We used to warehouse mentally ill people. We don't anymore. That's a big improvement. But because we don't, the standard to hold somebody is very high, like proving beyond a reasonable doubt that they're imminently dangerous to themselves or others. There are a lot of people who are dangerous, but not imminently dangerous to themselves or others. Or they're so paranoid they won't cooperate with the lawyer. I get them in the court, what's your name? I'm not telling you my name. Why aren't you telling my name? You don't need to know my name. You should know my name. And so, those sorts of things are difficult. I'm going to try to pop up a picture of a client that I represented when I was still an attorney. So I was an attorney for 30-something years or whatever. And I did a variety of things, but I did heavy criminal defense work, among other things. I was what they call murderless certified and Criminal Justice Act certified. So I did drug cases on the Superior Court side. I also did federal criminal defense work. So I represented a lot of clients who had issues, and some of them got high publicity. And the other thing you deal with now is there's media everywhere, right? So you're trying to make sure that your client gets a fair trial in the midst of all the media, and you're trying to treat each person as individual and go along with that, but you're kind of fighting back against that. I never wanted my clients to get media attention. It wasn't helpful. They said, well, put it on your website. I said, well, that's helpful to me. It's not helpful to my client. And they'd say, we'd like to humanize your client. I'm like, well, you're going to have a very hard time humanizing my client. I like my client, I get along with my client, but the public isn't going to understand my client. Different courts have a different number of judges. There are many more district courts than there are superior courts, because there are many more people in district court. So district court might have several hundred, 200 or 300. Superior court has 82 statewide, and sometimes you run into a shortage. So this is Caius Veovis. Now the picture doesn't really do him justice, because it's blown up a little bit too much. These are horn implants in his head, all right? You can see the implants a little more. In between the horn implants is 666 tattooed on his head, all right? So, and that's me right there when I was a little younger. Mr. Veovis, Caius, was accused with two other men, a sergeant at arms of the Hells Angels and a member of the Aryan Brotherhood, and a blood-drinking Satanist, of killing and dismembering 3 men and burying them in 15 garbage bags, all right? So when you're in the court system and you're trying to be fair to everybody, and this is the stuff that gets put out on the media, that's what you're pushing back against. And so eventually he went to a trial. Eventually he got convicted, and he's now serving 3 consecutive life sentences. But he got huge attention. Now this was out in Pittsfield, but his booking photo went worldwide. And they had it on the various Fleet Sheet, or whatever they call it out in Britain, the scariest defendant you've ever seen. And then he unfortunately wrote a letter to saying, everybody's confusing me with Twilight or whatever it was. It was the Twilight series for young adults or whatever. So he wrote to the paper, I'm very upset about being confused with Twilight. I'm a serious Satanist, that's blather. Don't confuse me with the two. So he wasn't always his best, he didn't put his best foot forward. This is him in court at his trial. This is a young woman who was very friendly with him, all right? So she's testifying that at the time of the alleged murder, I was actually with him. I was upstairs with him, all right? And so we had an alibi defense, which unfortunately didn't really carry the day. But this is what you're up against. Like, you have this big thing, presented to the jury, and you're trying to say, put that out of your mind and listen to the evidence. My argument was that they never saw him at the time that the murder supposedly happened, which was during a hurricane. They knew sort of where the other 2 gentlemen were, but they didn't know where he was. And I'm like, he's radioactive. Like, you can't, if nobody saw him, he wasn't there. We can be pretty sure about that. So the jury deliberated 3.5 or 4.5 days, and they eventually convicted him. But, we tried to We tried to do for him what we could. And he got a fair trial. He was goth. I mean, beyond goth, you know. And I'm like, this has nothing to do with anything. This is a machete. So obviously when you've dismembered 3 men, a machete might be helpful. But we went through the forensics of it, and they did what they called, they luminoled all his implements. So that means they're looking for what we call occult blood you can't see, but it reacts to this, and then they use a blue light on it. Well, none of his implements came up with any blood on them. So I'm arguing like not only is that not prejudicial, it's helpful. Like you've looked, and the police didn't keep it as evidence. So I'm arguing, well, if it were evidence, police 101 is you keep it. So we had a lot to argue about, argue in his favor. Unfortunately, it all didn't really work, but when you think things are taking a long time or they're going slowly in court, we're really just trying to be fair to everybody. So this is a jury instruction which we give now in all our cases. Right? I don't know if I'll read the whole thing, but it's about 2 pages long. But we give this at the beginning of the trial, we give it at the end of the trial. Be fair. Let's turn to another important issue that I raised with you at the beginning of this trial. Our system of justice depends upon judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair. I'm sure you want to be fair, but that is not always easy. And we go into implicit bias, and we give them some advice as to how, slow down, take your time, speak to other people, be open-minded, listen to them, but also tell them what you're thinking, because you're telling them what you're thinking may help them to realize that they're thinking about something incorrectly. So like I said, I'd been a lawyer a long time before I became a judge, and I would say the system has definitely improved. I mean, and it used to be when I was starting and you had somebody with a Hispanic heritage who was charged with trafficking in drugs, I think there was much more implicit bias about that. Those people traffic in drugs. I think jurors are much more aware of it. I think as a society we're much more aware of it. We're not perfect in any way, but it has improved a whole lot. So that's Elsa Oliver. Some of you may have heard about Elsa Oliver because she was local. So she was a woman from Fitchburg, and she had a son by the name of Jeremiah Oliver. And Jeremiah Oliver disappeared, and DCF couldn't find him. And then eventually, a year and a half later or whatever, they found him, unfortunately, on the side of Route 190 in a suitcase. He was dead. He'd been dead for a long time. All right? So I represented her. All right? And again, this is the kind of thing that you're working against. All right? I'm not going to tell you anything that's still attorney-client privilege. That goes to the grave. You can never talk about that. But I can say publicly, because it's been discussed, she had mental health issues. She had severe mental health issues, as I said before. She was actually a parent to, I think she had 3 children. She was basically a single parent. Her mother was deaf, so Elsa was both sort of raised in sign language and came from a Spanish-speaking background, so sign language, Spanish, and English, sort of raised in that sort of environment. So not the best education in the world. Had undergone some difficult things herself as a child and some violence, and was actually a decent mother at times, but didn't have help. Her husband had drug problems himself, which is what happens sometimes. You have people who really, unfortunately, they're not the best pairing, but that's the world they're living in, and they tend to come across each other. She had to be put under medication at times while I represented her, and she could be both very paranoid, and then she'd be on medication, and she'd be entirely agreeable. She'd also have massive weight gain, so it would balloon up and down, both in terms of her physical appearance and her receptiveness to what you were doing. And this, of course, got all sorts of attention. It was all over the globe, and DCF was got a lot of attention about it. And at DCF, again, the system doesn't have all the funds that it needs, just like medicine or education. All right, so DCF is underfunded and understaffed. I'm making a pitch for them, but this is Elsa Oliver living in a difficult neighborhood in Fitchburg around people who can be difficult. You're a DCF worker. You're trying to go check on these people. It's not the safest place for you to be, And as a lawyer or a judge, we can't get them to show up for court. And now you're asking a DCF worker, and many of them on the front line are pretty young, newly out of school, younger women, and they're going into dangerous areas with non-compliant people. So again, bear in mind, it's not as simple as people make it out to be. And she had a boyfriend. Now, he is charged with the murder, finally, because this was years ago. I think his case is still proceeding. She eventually pleaded out. I became a judge during the pendency of this, so I represented her for like 2 or 3 years. Then I was appointed to the bench, so I couldn't represent her anymore. But she eventually pleaded out, I think, to child endangerment. And she got, basically time served. But people demonize her, and she's a person. And I'm not saying she's perfect. Nobody's perfect, and I'm not claiming my clients are all perfect. But she was treated fairly. She got mental health treatment. She got evaluations. And when somebody isn't understanding what's going on or they're not competent, we don't put them to a trial. And the media attention is not generally helpful. But you can't really avoid it either. So when I would get calls about people like Elsa Oliver or whatever, if I ever did talk to anybody, and I rarely would talk to anybody, I would always try to talk to them off the record. And I would try to, what they said, humanize it. Now, Caius, just before he went to trial, somebody from 48 Hours or 60 Minutes or whatever came and they said, we want to visit him in jail and get his side of the story. I said, well, that's a bad idea. And they said, well, we want to present him to the public and humanize him. And I'm like, I don't think that's going to work either. but and I don't want to get into the Karen Reed trial too much, obviously. And I'm not going to comment on it. I know Judge Cannoni, but I'm not going to comment on it. But we have an open court system in the state courts in Massachusetts. The media and the public have a right to be there. And I'm all in favor of open trials. But you're not getting the whole thing. You're getting snippets, you're getting selections, and it's not the same as being there. And so I think it gives a slanted concept of what the court is, and that's not particularly helpful. So this is what I'll do is I'll play for you a mock bail argument, because that's the other thing we do a lot, like bails, and you see those sort of the glimmers of them on television. And I think everybody understands, bail is the decision whether the defendant is going to be held or not held on a cash bail prior to trial. Again, there's been a lot of evolution about bail, especially in the last decade. One thing that bail can do that you don't want it to do is it can compel pleas. All right, so again, I was a lawyer for a long time. It was pretty routine to hold somebody pre-trial on a bail. The goal was, not goal, but they were dangerous, they committed an offense. I mean, they've been held, they've been probable cause anyway. And so let's just know where they are and let's not let them out. But since a trial takes 2 to 3 years to get to trial, a case takes 2 to 3 years to get to trial, if you've held somebody on bail for 2 years and you're offering them a deal of 3.5 to 4.5 years if they plead out, they're going to plead out most of the time just because they don't want to run the risk and the trial may get continued anyway and they have an out date. So I had a lot of cases I thought, well, this was probably triable, but I could lose it, in which case, I lose it, I go home. My client does not. So the client would say, sure, I'll do that because I just want it to be out. I just want a date. And in that sense, I've often said, it's kind of like waiting on a biopsy, or it's kind of like undergoing chemotherapy. It's like, is it going to work or is it not? I need an end to it. I need to know one way or another. And so people would plead out. And we realized that was not good and it wasn't helpful. And some people who weren't exactly what we call criminogenic or likely to continue to be criminals would be in a bad environment, and that would encourage them to be criminals or discourage them from something else. So we lowered bail a lot. There was a time when I was a lawyer when there used to be a review every afternoon of the number of inmates at the Worcester County House of Correction up the street. Because there was a consent decree. You have too many people here. It's cruel and unusual. It violates the Constitution. So, okay, we have a shoplifter, and we have somebody who's made a threat, and we have 2 people charged with rape, and we have another person charged with arson. So we're going to let the lower level people out. We're just going to let them go. And the Supreme Court of Massachusetts has made a lot of rulings in the last 5 to 10 years that people are really entitled to bail unless there's a good reason not to. And So what will happen is they'll get held, and then after 6 months, if they can't afford it, we start reducing it because they have a right to be out. And we never know if they're really telling the truth on how much bail they can afford, particularly initially. So we'll set a bail that looks reasonable. But if after 5 or 6 months they haven't paid it, their family hasn't paid it, you can assume they really can't pay it. And then you start looking at they shouldn't be held that long. But they'll be out on an ankle bracelet, and we'll have either an inclusion zone, which means oftentimes I'll put them on home confinement. All right? So you have a drug problem, you have an alcohol problem. I don't want you out and about. Now you're under the stress and the strain of possibly going to jail or having all this emotional weight on you. You're probably going to decompensate. So I don't want you out and about. So I'll put you on an ankle bracelet with home confinement with what we call windows, which means options for legal and medical appointments. If you really haven't had much of a problem, but you still seem like we need to keep you monitored in some way, sometimes they'll be on an ankle bracelet for a while and they'll get a job. And they're like, I can work at this tire store. Or I was working at the tire store and my boss is willing to give me the job back. Okay, we're going to make that an inclusion zone. You can be at work from 9 to 5, but you have to be there from 9 to 5. If you're wandering off somewhere, then we think you're doing something, and that's not permissible. Or you have to stay away from the alleged victim. There's an exclusion zone for wherever the alleged victim is. So you have much better management of that. I think I'm correct, and I hope I'm correct because I'm being recorded, but I believe Massachusetts has the lowest incarceration rate in the country right now. So that's a good thing, generally. Unfortunately, in the court that I am in, we incarcerate more people because the crimes are more serious. Right. And by the time they're kind of up to us, some of the options that you have in district court aren't as available. We still work with them. We get them into programs. I will often I'll try to explain why I'm doing something on the record. I'm not putting this person in jail for a long time. This person's 25 years old. This person's 23 years old. I'm putting him in jail for 2 years or 3 years, and then I'm putting him on 3 years probation. I know you want me to put him in jail for 5 years, but he's still going to be in his 20s when he comes out. And if he's been in jail that much longer, and now he's unsupervised because he's not on probation, I think I've just made a more angry, more upset, more disadvantaged person who's still plenty physically young and plenty physically capable of doing some things that we don't want him to do. So it isn't so much forgiveness or leniency, it's trying to find the right mixture of things. And there has to be some punishment, all right? There has to be some level of punishment. Well, they've always demanded strict punishment. I don't know that that's more now, and I can say victims often go that route, yes. So we have victim impact statements as sentencing. The family or the relatives are entitled to say something. And some of them get pretty harsh, and they ask for the maximum sentence. That hasn't really changed that much. You also see amazing people who'll say amazing things. You know, one of the really hard cases is the vehicular homicides where somebody's drunk. Those are really hard. And oftentimes they involve young people or somebody supposedly really drunk and somebody supposedly absolutely innocent or not or whatever. And it's not usually like that. It's usually two people have been drinking and somebody made the bad decision to drive and somebody else made the bad decision to get in the car. But, you know, you have this terrible thing. But I have seen parents get up and say, you know, I forgive you. Like, I understand how that could have happened. You were my son's friend, and I don't want your life ruined by this. That's not as common, but it happens. Most of the time, it's you should go to jail forever and you're a bad person. So we listen to that, and we try to be fair. We have guidelines. The guidelines are not mandatory, but people put a lot of time and effort into thinking this is what is an approximately right sentence. And so they're a good sort of anchor. You can vary from it, but it's always good to come back there. We also don't generally do sentencing the same day. I don't want to do sentencing the same day that somebody's convicted because my emotions are up. And I'm trying to wind down and think and be a little bit removed from it. But it is kind of chaotic. I just, as I was going to come here, I looked at what I did today, and this is a sampling of like a day that I had. So this morning, I was specially assigned to a case out in Hamden because the defendant had some low P political connections, not like state representatives, but just some of the people that he was associated with were employed by the court system. So they said, okay, somebody not from Springfield is going to hear this. So they sent me out there. So this was a 37-year-old man who went to trial last week. He had a 3-day trial before me, 3 or 4 day trial. He was convicted of armed assault with intent to murder and other crimes. He shot a man at close range 5 times because he had a sandwich with bacon in it, and he got upset. And so I have no idea why he did that. He's 37 years old. He had private school education. He had graduated from college. He had a minimal criminal background. He asked the cook give him a sandwich. The cook said, "Here, have some of my sandwich." He ate it. He supposedly said, "There's some bacon in here." He never testified. I don't know that he's Muslim. I have no idea why he was upset about the bacon. He and the cook got in a little bit of a fisticuffs for about 5 or 6 seconds, and he literally said, "If you're here when I get back, I'll kill you. You're a dead man walking." This is all on video. So a half an hour later, he came back, shot the cook 3 times from 2 feet away. Cook fell down, and he shot him twice while he was lying on the ground. Right? So I don't know. I offered him a plea bargain earlier, which was, I think, fairly lenient. He decided to go to trial. I gave him an 18 to 20 year sentence with some time on and after on another charge. His family was amazed, just dumbfounded. How could you possibly do this? He's such a nice guy. He had one bad day. But you really see both sides of it, and you'll get these very heartfelt letters. He's a wonderful person. And sometimes they are. And I said, this is incomprehensible to me. I cannot put these 2 people together. And I don't exactly see the person that you see, family out there in the pews, but you don't see the person I see. And the person I see is on video, and I said, this was a murder. The young man did not die. He was about, I think the cook was about in his mid-20s. He was largely paralyzed from the waist down. He's slowly starting to learn to walk again, but it was a murder, it just didn't happen to be a murder. So I did that last week. I came back and sentenced him this morning, took a few days off. We're not going to sentence him right now. We're going to think about it. The victim didn't want anything to do with it, so he never showed up in court. So the Commonwealth had to go prosecute the case without the victim. They didn't need him. They had video and they had eyewitness testimony and things like that. But here's a victim who you would think would be screaming to high heaven, I want this guy punished. He never even appeared at the trial. He's sort of traumatized. I don't know what else is happening, but he didn't show up. I then came back to Worcester Superior Court in the morning, because I'm in what we call the first session, which is where a lot of the pleas and negotiations happen. And I sentenced a 27-year-old man to 4 to 6 years in state prison. He's what we call an ACC1, Armed Career Criminal 1, which means he had a prior serious drug offense or prior firearm offense. He's 27 years old. He had I don't know if it was a Ruger or whatever, but he had a high-capacity firearm, a high-capacity pistol, which means it holds 10 rounds or more. And he put a Glock switch in it, which means it turns it to completely automatic. All right. He also had 3 children, and apparently he was living with his girlfriend, like out in Holden or Jefferson. I'm like, I don't know how this is happening out there, but that's not usually where we see it from. And I think it was his girlfriend's mother or somebody sort of knowing what he's like, and he's living there with at least one of the kids, or I don't know, maybe another one of the kids. She sees that there's like a fanny pack or a bag like near where one of the kids is sleeping, and she picks it up. She says, this is heavy. I'm very concerned. So she calls the police, and lo and behold, there's a gun next to a sleeping child, which is a fully automatic now firearm. So he's got at least 1 prior conviction, and so he's got a mandatory 3 years if he's pleads to everything. And since he already had a bit of a record, he was getting 4 to 6. Now he'd only been in, I don't know, maybe half a year or something. So he's a 27-year-old with 3 children who's going to be in jail until he's at least 30. And he's got, as I think he had 3 children. I think that's what they told me. And so you can see this repetition happening in front of you. And you're like, I don't like this. I really didn't enjoy sentencing the other guy to 18 to 20 years. And he has 2 children. He has a daughter who's like 13 and a daughter who's like 9. And the family's arguing, don't take our father away from them. I'm like, well, I don't want to. But on the other hand, this other guy should be dead. I mean, there's no explanation for what you did. And at that point, there has to be some significant penalty. There's only so much you can do. And right after that, I get a 23-year-old man who's a refugee from Somalia. I don't know if he's a citizen or not. We don't ask about their citizenship. It's not generally on the paperwork we get. I don't want it to affect what I'm doing, so I don't ask about it. But he has some significant mental health problems. He's deteriorating. This seemed to have come up fairly recently. And again, he's about the age where some of these conditions manifest themselves. He's not competent. He can't, he's so paranoid, I can't even talk to him. So I can't do anything in terms of a probation violation or sentencing him or whatever. He's been evaluated and the doctor says he's not competent, but he's not acutely dangerous to himself or others. He doesn't have suicidal ideation or homicidal ideation. So I don't think he needs to be held at Bridgewater State Hospital or the Worcester Treatment Center. Well, if the doctor says he doesn't need to be held, I really don't have the authority to hold him because I need that basis of evidence to hold him. Families will say, well, we'll take him back. Part of the problem is he's accused of hitting his mother because he's paranoid about his mother. And again, the families want to help out, which is a compliment to them, but you're like, I can't let you go back there because part of your paranoia is you don't trust your family. On the other hand, I don't have any place to send you, and you don't have any place to go. So I really had no good resolution for that case. Now, the way it works is he's on a case in our court for violating his probation. He had a drug charge, and part of the drug charge was he was supposed to do certain things. Well, while he's on probation for that case, he allegedly attacked his mother. So he has a case pending against him in Worcester District Court for attacking his mother. So he has a bail or conditions on that case, and he has a potential violation of probation on the case that I have. So eventually I just said, I'm going to just terminate his probation unsuccessfully because it's been a year. He hasn't been competent for a year, and he's not going to become competent. He won't take his medication because he's paranoid and doesn't think anything's wrong with him. I can't force him to take his medication because he's not acutely dangerous. I can't override his civil rights to make him take his medication. So those are just sort of a normal, typical day of things that you're going through. A little heavier than some. They're not all quite like that, but I have a great job. I get to try to do something for people every day. I get to be involved in a wonderful system that's very underfunded, and I'm not saying for me, I'm saying like my wife's been in the school system for a million years. She's a school psychologist, so she's worked in Brockton and other places. She's worked in Natick. She's worked all over. Yeah, so I mean, it's a great country. We do great things. I'm very proud to be here. There's always something more you can do, just like, medicine. Like, I wish there were more funds for medicine. I wish insurance didn't cost what it costs. I wish we could be more helpful. So that sort of thing. But it's a privilege to be able to do it. Like, most people don't get to do it. And, sometimes you're like, I'm a judge. You're like, how did that happen? Like that. My wife always says, you're not a judge at home. And I'm like, I know that. I never thought that. I have no expectation. I understand who runs the situation here. There was never any miscommunication about that. So, but it's weird. I mean, sometimes, it's weird. Like you just sent somebody to jail for 18 years. And you're like, that's a strange thing. And who said I should do that or that I could do that or that I'm the person to do it? But it's fascinating. You're trying to help people. I do believe in the system. I regret its shortcomings. I do think it's gotten better. But, it's hard. I did 5 child rapes or 6 child rapes in 2 months. That wears on you. And sometimes you have to take a break. And they're not probably 2 or 3 trials and 3 pleas. And those are among the most egregious cases. I mean, they're horrible. Almost everything has some level of gray. You really don't know what happened. Most of the people you're dealing with are not great witnesses. They're not great historians. Their backgrounds are somewhat fractured. There's no such thing as a perfect family. It just doesn't exist. But
it's not like TV?
It's not like TV. And you just reminded me of something. One of the great things about being a judge is you get to go back afterwards and speak with the jurors and thank them for their service. So like I was a lawyer for 35 years, probably something like that, I guess. And you can't have any contact with them. So you never knew what you did right or wrong or what they thought of you or whatever. So we go back and thank them for their service and ask them what they thought, the pros and the cons. I always say, don't tell me about your deliberations. I don't want to know anything about that. And we also get, jurors will respond to surveys. Like everything, it's probably 1 out of 100, but we get them every month, And most of the people who are picked for jury service are very appreciative and very laudatory. They're like, this was wonderful. I appreciate. I didn't want to go. I was afraid, and everybody took it seriously. So you know, it's nice. The ironic thing is that the people who don't get picked for service are very mad. They're like, why did I come in? Why did I have to wait long? Why did I have to wait so long? But it's uplifting to hear what they think about it. And it's one of the few, I'm not going to get political. I'm not supposed to be political, and I'm not in that sense. But I do say to them, it is amazing that we can take 12 of you off the street who don't know each other. We can go through a process called voir dire, where we ask you, do you have any axe to grind in this case, any reason you can't hear it? We'll put you in, we'll take a week of your life or 2 weeks of your life, we'll put you in this very intense situation, you'll make a decision, and you'll fulfill your obligation. I don't know of any other country that does that. And I'm not familiar with every other country's legal situation, but most of them have civil tribunals. It's not really jury trials. It's amazing. It's one of the last bastions of things that is completely, as much as we can, make it apolitical. You have a question?
Yeah. Can you talk about how the cases are assigned to you, for example? You just mentioned that you had
out in Hamden.
Rape cases.
Yeah.
So they know that, hey, you went through this trauma, and should we give you a sixth one, you know?
Yeah, so we have, in Worcester, we have 3 criminal sessions in Superior Court, and we have 4 civil sessions. So we have 7 sessions, technically. Now, they're not usually all up and running at the same time. There's been a shortage of Superior Court judges. We've been down like 10 statewide. We're slowly getting back. So on the criminal side, we kind of discuss who gets which case, and it's kind of who's available. It's not, nobody sort of self-selects them. I am right now, this does not mean anything, but I'm right now what they call a regional administrative justice, which RAJ, regional administrative justice, which you say really means really awful job, because I'm kind of one of the schedulers, but we have a very good group of judges who get along very well, and we're all just trying to do the work. So what will typically happen is something will come along and we'll say, okay, we have this child rape coming up in 2 weeks. And this judge is involved in that trial, and that judge is involved in this trial. And we have another judge, but that's a newer judge who hasn't really done criminal work. So I'll take this, I'll switch out of my session, and I'll take this because I have experience with this. And that other judge will switch into that session and take that case. So we distribute them fairly evenly as much as we can, and we see who's available. And you know, some judge may be on vacation a certain week, or somebody may be having surgery in their family. So it's not entirely random, but it's close to random. It's just who's available to do it. But you raise a good point. I mean, we are looking into judicial wellness and things like that. Most of us it's what we do. A lot of us kind of were used to it before. We were lawyers before. We were trial attorneys before. My father was a lawyer. I'm one of 8 children, and 5 of them are lawyers. So I kind of grew up in it. I don't think we're type A. I don't think. But you have to have you have to want to do the work. You have to be somebody who's committed to doing stuff. And sometimes we probably do get overcommitted. And among ourselves, we'll kind of be like, hey, you know, I don't think you should do this one. Or I'm going to, as the Raj, I'm looking around, I'm like, you know what, you just did 3, I'm not going to put this, I'll do it. No, I don't think you, I'm going to give it to somebody else.
Does a judge have a right to override a jury decision? And if so, have you ever done it?
I have never done it. I have a hypothetical right to do it. The standard is very high. I would be incredibly hesitant to do it because the jury verdict is pretty much sacrosanct. I haven't ever found one where I thought it was so egregiously wrong that I would override it. And if I did, it would be subject to appeal. You know, nobody can appeal a not guilty. A not guilty is a not guilty. That's double jeopardy. You can't do anything about that. But if they were convicted and I overrode it, and I can either find them not guilty or I can reduce it. It's not murder, it's manslaughter. It's not murder 1, it's murder 2. But that has a right of appeal by the Commonwealth. So, you know, we do get motions for a new trial and things like that, particularly with, you know, the judge is retired. So somebody might have been convicted 10, 15 years ago. And now that judge, whoever heard the trial, has moved on, is retired. So we're now trying to review a trial that we didn't even sit at and see if there's a reason to give them a new trial or a reason to vacate their conviction or whatever. So we do get those, and as the Raj, they come through me right now, and I can assign them to other people. I've had a couple that were close. And the other thing that's hard is, there were decisions made 20 years ago that are not what we would do today. So you're struggling with whatever, but that doesn't mean that I get to change what somebody decided 20 years ago. And most of the ones I see seem to be pretty legitimate convictions. There's a very different thinking now about young people than there used to be. So people now who committed a murder when they were 20 years or younger, they're not subject to automatic life in prison. They were, but they're not anymore. So now we're getting these cases where somebody's been in jail for 30 years who committed a murder at age 18 or 19 or 20, and they're hypothetically entitled to parole. So that's not really coming up before us because that's a parole board issue, but it's filtering through some of what we do because our Supreme Court of Massachusetts, has declared court is always behind science, and it's generally common sense, but sometimes it's not always common sense. So scientists, neurologists with a lot of study have now determined that young people, particularly young men, sometimes do stupid things impulsively. So this has now been determined scientifically is now a principle of law. So we have to understand that young people do things impulsively. All right? So young men tend to do things impulsively, and we should look at that when we're sentencing them or convicting them because it says at 25 your frontal lobe is fully developed, hypothetically. I will also say, having been a lawyer for a long time and dealt with a whole bunch of couples and a whole bunch of people in dire distress, young women make bad decisions too. It's just usually they involve young men. So these are common sense things that we kind of know if you're in the system, but they're also it's hard to tell. Like I've been involved in a lot of restraining orders, domestic violence restraining orders as an attorney and a judge. I think I was involved in 4 or 5 domestic homicides, at least a couple of which the guy got a restraining order, went down, barricaded the apartment and beat the woman to death. So the restraining order set him off. I mean, he's probably going to be set off anyway, and that's not a reason not to get a restraining order, but you never know. And 99 of them will be fine. Most people obey them generally, but some people don't. I had a guy who they took away his firearms. He found some way to email or order an antique cap and ball pistol to a post office box in Maine because it wasn't technically a firearm or something. This is like 30 years ago. And he went up there and got it, and he had a final pretrial on his divorce and shot his wife in a parking lot. So I mean, people can be infinitely focused, infinitely invested. You just can't tell. And you use your best judgment, and most of the time we're right. Some of the time we're wrong. The other thing you can't do is you can't make every decision guarding against the worst possible result because you just can't function that way. And then you'll hold everybody. You'll just, I'm not going to let him, I'm not going to let, whatever. And that's not the law, and that's not fair. So it's you do the best you can.
Related to her question about judge overruling the jury.
Yes.
I just remember one case many years ago here in Massachusetts where an au pair was convicted.
Yeah. Yep.
I just wanted to share.
So that was an au pair. I almost can remember the name of the case, but I can't right now. It was a nanny case, and she was from Ireland. So part of what happened in that case, so that's what we've typically called a shaken baby case, all right? And the forensics, the science of shaken baby cases has changed a lot. So one of the things when I talk to young people about becoming a judge, I'm like, learn everything you can. There's a lot of science involved in being a judge, and it's more and more every day. So I was pre-med in college for like 2 years, and then I said, well, I love the science, but I didn't like the rote memorization and the regurgitation. So I, went another route. But that helps me, anything you learn, because it's a lifetime job, you're going to be learning all the time. I mean, right now we're doing a lot of things with, we're always doing things with cell phones and electronic evidence. I'm on the Superior Court Judge Technology Committee, so I'm doing a lot of studying of AI and how that's likely to affect us. So the shaken baby case, no, it's going to bother me, I can't remember her name, but it'll come to me as soon as I leave. I can see it right there too. So I've had a few of those cases, and the injuries that newborns can sustain and how they can sustain them and what they actually are, there's been a huge scientific dispute about that. Kind of like whether vaccines cause autism, on that level of scientific dispute. And what happened is Louise Woodward, and it's almost 7, so I'm still functioning. You know, I think at that point, and I can't remember the judge's name, but the judge just decided that the evidence wasn't really there. We've had a number of those cases overturned, actually convictions, because people thought that the science indicated one thing, and they came to realize that it didn't. Brain bleeds in young children are very much discussed by forensic people. And they're horrible cases, and most of the time they're black box cases. I call them black box cases because the child was potentially in the custody of, or in the vicinity of 5 or 6 different people, because they don't generally know when it happened. It's like somebody calls and says, oh my God, the kid isn't breathing. Well, I don't know, last night I was here and they were there, and so it's like, and the doctor can say sometime in the last 4 or 5 hours or 8 hours or some window, this person suffered an injury, but who caused it, we don't know. So yeah, science is always advancing faster than the law can keep up with it. Cell phones have been like that. We have a lot of rulings about cell phones now, and so this is a bail review on, I think, a vehicular homicide, a bail argument. So you can watch and then we'll have some questions about it.
I'll rise to stand.
Good morning. Good morning, Your Honor.
Thank you. You may be seated. Docket number 18 CR 952, Commonwealth versus Alan Sharp.
Good morning, counsel. Good morning, Mr. Sharp. It's my understanding that Mr. Sharp was arraigned earlier this morning. Does the Commonwealth move for bail?
Yes, we do, Your Honor.
Is the defense prepared to go forward?
We are, Your Honor.
I'm happy to hear from you, sir.
Thank you. Your Honor, this case arises out of a motor vehicle incident that took place on January 1st of 2019. The evidence suggests that a little after 7 a.m. on that morning, Mr. Sharp, the defendant, was driving his Ford F-250 pickup truck eastbound on Route 9. As Mr. Sharp approached the area of the Natick Mall and a traffic light that was located there, he was going in excess of 80 miles an hour, went through the red light without stopping and struck another vehicle being driven by the female victim, in this case, Eileen O'Toole. Ms. O'Toole was killed instantly upon impact. Mr. Sharp was then taken to Newton Wellesley Hospital for the treatment of some minor injuries sustained in the accident, where it was determined that he had a blood alcohol level of 0.30. As the court knows, that is in excess of 3 times the legal limit. This is not Mr. Sharp's only contact with the law regarding OUI. This is his second case. He has a prior conviction for OUI that ended in a probationary term in 2017. His probationary term on that case had only been 2 months old, or at least had only ended 2 months prior when this incident took place. He also has a default history arising out of that very same incident, Your Honor, on which he did fail to show up for the first day of trial. Your Honor, in light of the seriousness and the strength of the case in this instance, as well as Mr. Sharp's prior OUI history and his default history, the Commonwealth is seeking $100,000 in cash bail.
All right, thank you. May I please see Mr. Sharp's record? Thank you. Counsel, I'm happy to hear from you.
Thank you, Your Honor. In this case, Your Honor, Mr. Sharp has strong ties to the community. I would suggest that in this case he owns a house in the community, he has his own business in the community, he lives in the house with his mother, from whom he is a caretaker in the community, and he's a lifelong resident of the community. So I would suggest that he has strong ties to the community, Judge, and then I would explain to the court that with respect to his ability to comply with the terms and conditions of release, he has successfully completed the continuance without a finding on 2 different occasions. So that demonstrates to the court that he can comply with the terms and conditions of release that the court sets in this case, Judge. I think the biggest issue for the Commonwealth is the issue that they don't want to risk to the public by Mr. Shop drinking and driving. And I would suggest that this court can solve that by means other than locking Mr. Shop up, by ordering that Mr. Shop, at his own expense, attach a device to his car that would prevent him, it would have to blow into it and would prevent him from ever even starting the engine if he had any alcohol in his system whatsoever. I think that's more than sufficient, Judge, to protect the public in this case, and I would suggest that a $25,000 cash bail plus the order of attaching the device to his house, to his car is more than sufficient to assure his presence, Judge, and I'd ask you to consider a $25,000 cash bail.
Thank you. In reviewing Mr. Sharp's intake, I note that he owns a small excavation company in Natick, reports annual income in excess of $200,000, owns his home as well as 2 motor vehicles. Is that correct?
It is, Your Honor, but the fact that he reports income of $200,000 should not be taken by this court as any indication that he can pay a $100,000 cash bail. I've spoken to Mr. Sharp. He tells me that he has $25,000 available for a bail in this case, Your Honor. But the money that he makes has to not only support his business and enable him to pay his mortgage and support his mother, but it also is money that he has to live. So I would suggest that a $25,000 cash bail is more than sufficient to secure his presence here in court.
Thank you very much, counsel. I've taken your arguments into consideration as well as the law pertaining to bail. Now you be the judge.
So as a judge, I had a little experience through my daughter with the court system.
Yep.
And it took over a year for what was considered really very minor.
Yep.
But when you went up there, so when she appeared before you, they, wasn't her, it was the guy, you look at that information right then and there, you don't do any homework, so to speak.
No.
So you have to make snap judgments.
Yes, I mean, we generally do because it's fast moving, right? And there's just a lot of moving parts. So, you know, I don't have as many cases as a busy district court judge would, but I have higher bail decisions. I mean, a lot of theirs are going to be, I'm letting you go on personal recognizance, which means you're not paying any bail. Or, and with us, it's generally there's going to be some kind of bail. But they give me the record and I review it. I will take my time. Occasionally, if it's a complicated thing, I'll say, well, we're going to take a recess. And I'm going to think about this if I'm trying to fashion something. But yes, it's a good point. It's fast moving. I don't know the person. I mean, they've just come in. They've been arraigned. You know, and here's what we're asking for. And the Commonwealth asked for one thing, and the defendant asked for another thing. And, you know, I'm trying to make a decision on the fly. Anybody have any thoughts about what was said there? No, the judge hasn't said what he would do. Anything stand out to anybody?
So he killed someone, or he killed?
He got in a car accident, and his car hit another car, and killed the person in the car died. Yes,
Died.
yes,
And he's looking for bail.
yes. He's looking for bail.
He killed someone, and he's looking for bail for $25,000.
Yes, but remember, there's a presumption of innocence. Like, we don't know that it's his fault yet. Not all car accidents are somebody's fault.
Right.
All right. So we don't know. Maybe the other. They said he was going 80 miles an hour. That's what the prosecutor says. I don't know if that's true or not. I don't distrust the prosecutor, but we have accident reconstructionists who will come in and do the physics of it. We have electronic data recorders that are in cars, so they'll download the data. The other car may have run, they said he ran a red light, maybe the other car ran a red light. Maybe the red light malfunctioned. There's all sorts of things. So all I know is that he's charged with, and this is their statement about what happened.
He was driving drunk again.
Right.
Is the judge allowed to impose the breathalyzer independent of the bail?
Yes, the judge could impose the breathalyzer in a case like that. Now, this raises an important question, okay? Bail is not about whether somebody's dangerous. And I understand the public doesn't get that because it's a kind of strange concept. There are only certain charges that were allowed to hold somebody as dangerous. And there's a statute that specifically says that. If they're charged with these crimes, and mostly they're assaultive crimes, or they're high-level drug trafficking crimes, or they're firearm crimes. But we can't just hold somebody on bail we can't hold somebody as dangerous. So dangerous means they don't get bail. And in Superior Court, they're held for 180 days without any bail, because we've determined that they're too dangerous to have bail. But that expires in 180 days because, again, they haven't been convicted of anything and they have a right to bail. Now, at the end of the 180 days, they may get a high bail. You know, you may have served time for manslaughter and now you're charged with assault and battery by means of a dangerous weapon in way of evidence you shot somebody. So, okay, I held you for 180 days, now you're going to get bail. I'm still going to give you $50,000 bail. The purpose of bail is to make sure that you will appear in court. That's the purpose of bail. And so that's why they're saying things like he has a house, he has a mother, he has a business. He's not likely to just blow off because he'll destroy his whole life anyway. And he's committed to being here. Now, on OUI cases, oftentimes a breathalyzer is imposed with a guy like him who had 3 times the legal limit and had just recently gotten off probation for a prior OUI and is now facing, you know, the potential of a really serious jail sentence and also the loss of his license, which is what we call an ancillary consequence, but very important to most people. You might consider also what we call a scram. So a scram is a portable breathalyzer that has a cellular connection, and they just have to carry it around with them, and the beeper goes off and you got to blow into it. So, because the other thing I want to say is, paper orders are not magic. Just like I said with restraining orders, people violate them. They go, well, this guy's got 2 prior drunk driving and he's driving. Yes, he's driving illegally. He has a breathalyzer in his car. Guess what? He borrowed his girlfriend's car, or he borrowed his neighbor's car, or he, you know, whatever. So, you know, we can't follow them around and make sure they do everything they're supposed to do. And she made a good argument. Look, he lists $200,000 a year, but I don't know what he's paying his employees. I don't know what he's paying in taxes. I don't know what his mortgage is. So I'm thinking a little bit about safety, but safety is not what I'm ruling on. I'm ruling on whether he'll show up in court. All right? I don't get to keep him in jail just because I think he's unsafe. All right? There are other ways to do that. His family could section him. Right? There's a potential to section someone who's a bad alcoholic or a bad drug abuser. But you don't do that before me. You go to another court and you get a psychologist or doctor to say this person is an acute alcoholic or is an acute drug user and is not safe. Then the court will hold them on that. But my job is not to determine whether he's safe. I'm thinking about it a little bit back in my head, but my job is to say, is he entitled to bail? Will he show up for court? You know, we have court clinicians, court psychologists who are generally available. They're not there every day, but we do have people who show up and we're like, this person seems, something's off with them. And we'll have a court clinician evaluate them. And if they seem to be really not functioning very well, they'll get sent to Bridgewater State Hospital for a 40-day evaluation. You can put a GPS on them, which we didn't have. They didn't do so much back in the day. But yes, now he has a default, all right? They said he has a default on his earlier case. That means there was some court appearance he didn't show up for. Now, that may have been a technical thing. He may have forgotten, or there may have been a traffic issue, or it may be an issue. When we see the record, we're seeing those defaults. And you can pretty much tell, here's somebody who's 25 years old who has 4 defaults and has served 2 prison sentences. This is somebody who's not going to comply. They're just not getting it, you know. Or we'll have somebody who's 50 years old who's got a long record of breaking and entering and trespassing and uttering and forgery and shoplifting. That's a drug addict 9 times out of 10. That's somebody, they don't have crimes of violence. I mean, breaking and entering, most of the time, they're sort of careful and they're going into houses when people aren't around because they don't have an assaultive history. But you're a significant drug addict. And you're trying to weigh all that. And what you're trying to weigh that in sentencing. If you're 50 years old and you still have a long history of breaking and entering and trespassing and uttering, which means writing false checks or retail theft or whatever, it's getting less and less likely that you're going to change. That's just unfortunate. If you're 20, 21, 22, and you've had a few drug convictions, it's like, well, there's still time for you. There's still hope for you. And I don't really want to put you in jail for a long time because I don't think it's going to be helpful. I don't think it's going to be helpful to you or to society. The goal is to not just to be nice, so that jail is expensive. I mean, I think it's $80,000, $90,000 a year to have somebody in jail, and it's not doing much now. They have a lot of programs up at the House of Correction, and some of them work. So sometimes it helps. But punishment is one thing, but what are you getting out of the punishment? What are you getting for doing that?
So once a bail agreement has been decided on an amount, does that amount that money have to be paid before
Yes,
they're released?
they have to be paid before they're released, right.
So if he convicted, he doesn't get the money, or he
No, if he's convicted and he doesn't skip out during the case, they'll get the money back. The money is just to make sure you stay there until the case is done. So if he's convicted, he or his relative will come pick up the money. He would get some bail. I would probably put him on a GPS, certainly, because part of what you're concerned right away is this guy seems to have a problem with alcohol. And now the world is falling in on him. I mean, this is we all have anxiety. His anxiety is going to go through the roof. And his method of dealing with anxiety very well may be to drink.
Yes.
You know, so, I mean, it's kind of common sense, but those are the things that go through your head as a judge. The other good thing about this example is fairly realistic is if we put an unpayable or an insurmountable bail on him, his business goes down the drain. The people he's employing go down the drain. His family is struggling. That's not necessarily helpful, you know, generally to society, and it's not helpful to him. And as I said some time ago, you end up compelling pleas. Like, I gotta get out of it. You know, it's okay, it's bad, but in 6 months or another year, there's an end to it. Whereas if I go to trial, I may lose, I may get a longer sentence. So bail can have a compulsive element to it, and that's a lot of what the bail reform is about. We don't want people to be compelled to plead guilty. Because of COVID, we had all kinds of people that were released, right? Because we have an Eighth Amendment obligation not to subject them to cruel or unusual treatment. Well, locking people up in a very confined environment when society says you have to be social distancing is really not appropriate. So a lot of people got let out during COVID, plus you didn't want it to spread. Plus some of them are going to get out anyway. When they go out, understandably, they don't want to go back in, right? And so there's been a sort of a delay with COVID. It's like, yes, you've been out for 2 years or 3 years, but you still have a mandatory sentencing, and you're going to have to face up to that at some point. Now, surprisingly, some of them do very well. So you may have somebody who's out for 2 or 3 years and has done drug treatment and is okay and has a job. And now you're like, well, now I'm going to put them back in. This is where I wanted them to be if they'd served 2 years and come out. So, you know, some of it doesn't make sense, but there are people who just get punishment. I mean, it's not the first thing in your head generally, but some people, you know, we have to have some element of punishment and retribution for really severe things. You have a right to a speedy trial, to a trial within a year. But there's what we call Rule 36 of the Rules of Criminal Procedure, in which the exceptions swallow the rule. So anything that is sort of necessary for the cause of justice, those timeframes can be excluded. Anything where the defendant is filing a motion or waiting for a ruling on a motion or asks for a continuance can be excluded. Time that has to be excluded due to the ends of justice gets excluded. One of the things that the good and the bad, most things are both good and bad, all right? So we have so much evidence now, all right? So much more evidence than we used to. So when I started, I could try a major assaultive case or a rape case. I might have 7 pieces of paper. I might have a 2-page statement signed by my client where the police talked to him for 3 hours, and I'm like, there's 304 words here. You talked to him for, that's all we talked, oh yeah, that's all we talked about. I'm like, I don't think so. I think you talked about more than that. Oh, we talked about the Red Sox a little bit. Oh yeah, what are you talking about? Oh, just the Red Sox. So, but you didn't have stores didn't have videos. You didn't have cell phone records. You didn't have license plate readers. So if wherever you go right now, we're going to know where you went, all right? And that's not Big Brother, that's Google. That's your cell phone, that's everything else. Not the government watching you, it's everything else that you're doing. So the amount of data that we get is really high. To collect all that forensic data takes time. Then the defendant has a right to review it. The Commonwealth will have their expert review it. Then the defendant has the right to hire their own expert to review it. So all of that data really slows things down. And it's just getting more and more all the time because we're gathering more and more data all the time. So the bad news is it slows things down. The good news is incorrect identifications, grabbing the wrong person, that's probably going to happen almost never now because we just have this amount of stuff. But it's slowing things down, and So as judges, you're like, okay, this thing is on, it's the third time it's on for trial. Well, judge, you know, this DNA came back, or there's this other new test, and you're like, okay, everybody's entitled to it, but I'm ready to go, and it's been hanging on a long time, and there's an alleged victim out here, and evidence could be deteriorating. The police officer retired, whatever, you know, let's move it along. But there's a constitutional right to look at all this evidence, and it's just becoming more complicated. Now, the other sort of thing that's happening is we're starting to get AI programs that will digest the evidence. So hopefully that will help. Yes, so you can plug it all in, you can plug in video, you can plug in transcripts of depositions or whatever, and it will regurgitate, here's everywhere it says this thing, and it even can listen to the video. I think it's going to be able to find stoplights and cars in video evidence. I don't know if it's doing as good a job as whatever. That case I showed you, the Kayas Vajovic case, which had huge, I was nearly a sole practitioner. I received over 250 DVDs of evidence in that case, and tens of thousands of pages of discovery. And that was 12 years ago or something. So, I mean, that's what it's coming to. And I don't know the best way to handle that, but you certainly have to give people time to look through it. DNA takes a long time. It's not television.
Right.
A typical DNA request will probably take 8 months.
Yeah.
Fingerprints, same thing. Autopsy sometimes takes a year. It's underfunded and undermanned in some ways. I just wanted to show you another way, like we attempt to be fair, like the gentleman I was telling you who just shot somebody over a sandwich. So they had a photo array. I think we all know what photo arrays are. Instead of a lineup, they use photographs. So there's a whole process by which we try to be fair. So here is the instructions they gave to one of the witnesses, and it just says identification procedures. 1, you will be asked to view a set of photographs. 2, the alleged suspect's photograph may or may not be in the array. 3, it is just as important to clear a person from suspicion as to identify a person as a wrongdoer. 4, individual depicted in the photos may or may not appear exactly as they did on the date of the incident because features like weight, facial hair, etc. are subject to change. 5, regardless of whether an ID is made, the investigation will continue. And 6, in your own words, how certain are you of the ID? So we used to go through that, and these are like sort of FBI procedures or double-blind procedures. The other thing is the person showing the photo array, the officer showing the photo array can't know who the defendant is. So there can't be any facial or body language or anything which would try to maybe unconsciously cue somebody in. So these are all procedures that have been established over like the last 10 to 15 years. We're much more into sort of the social science. There's a very long instruction we give about identification, which is basically identification is very sketchy. Like it's not a tape recorder, you simply can't recall it. Cross-racial identifications are more difficult. If a weapon is shown, oftentimes you're very panicked about the weapon and you're not as likely to imprint on the person. You know, what was your level of fatigue? How close were you? What's your visual acuity? How good is all those sorts of... So we give an instruction that goes on for about 5 minutes, and it basically says, you know, just if eyewitness identification is all you have, you can convict on it, but be pretty skeptical about it. But now, like with this, we had video evidence. So again, this sort of people just getting convicted on an ID or a person's memory doesn't happen very much anymore. We call that the CSI effect in court. The downside is the jurors want it. Like, why didn't they do this? Why didn't they do that? Why didn't they do the other thing? Well, they don't have infinite money, and they don't have infinite resources, and it takes time. You know, so I don't know. It's always a process. It's always changing. One of the nice things about it is that you get to learn all the time, and you're always trying to keep up. And I like that part of it. If you're somebody who wants to do the same thing every day, don't do this job. It's not going to be the same thing every day. But I guess I'll kind of wind it up there, unless somebody has, if you want to have a few questions, I'm happy to try and answer them. I didn't get into the civil side, so I'm not going to go there. There are a lot of very interesting civil cases too. We have a lot of science and medical malpractice. We have products liability. We have a lot of, not a lot, but we have trespass to tree cases. So that's something that out here in Boylston might happen. So trees have a certain value. And if you cut them down, you're entitled to a certain amount of compensation. There are different ways to measure that. I think you're entitled to the replacement cost of a tree that's 3 inches at the trunk. You can't get a whole new, brand new tree. But there's also sort of strict liability for that. Sometimes you can get the diminution in the value of your property because the view has been changed by the loss of the trees. So I've had arborists testify at trial. So I had one guy who was an arborist who looked like an arborist. I mean, he looked like the wizard Gandalf, but I'm like, you're a druid. But you know, people are infinitely fascinating. They can be really bad, they can be really good, and you never know which they're going to be. But as much as there is a downside, there's some uplifting side to it too. And I hope I've given you a little bit of insight into it. And I'm always an advocate for the system. It's not perfect, but it tries hard. And I think generally when you actually have a trial, you get good service. I just wish it didn't take so long and cost so much money for people to get there. But I thank you for inviting me here. I apologize again that I didn't get here sooner, but
No problem.
these things happen.
Thank you.
All right.